You guys get tired of seeing my face? I wonder if you guys get tired of seeing us. I mean, me, Lauren, Donna, Zach, Shasti, Andy. Like, do you guys get tired? Because there's a lot of updates in this case, and they don't stop, like back to back, multiple times a day updates, multiple platforms. Just before I started recording this, I was like, oh my God, you're gonna have to see my face again. Do they get tired of it? I wonder. Let me know what you think. But nonetheless, I am here with another update. Justin Baldoni is opposing Blake Lively's ask for punitive damages, treble damages, all that. I'm going to catch you up really quickly. I'm going to try not to bore you because this one is very loaded, law speak wise. I'm going to try to make it as fun as possible, but I can't promise anything. Let's run. We got to go. Meet me on the other side. F around and find out. Hello there, beautiful people, and welcome back to another episode of F Around and Find Out. Like I said, I wonder if you guys are exhausted from seeing my face and hearing about this case. Honestly, I wonder. So please let me know in the comments what you think about it or what you want to see moving forward. If you want to see me talk about other things, I really want to know. I'm kind of taking a poll here because I wonder if you guys are getting, consumer fatigue from hearing from the story from 5-10 different content creators, and we're pretty much giving you the same information. I try to make it as unique as possible, but at the end of the day, I'm telling you the same thing. I'm gonna try my best not to bore you guys, but last night, just while I was recording that other video for you guys, it came on a docket, but again, I was exhausted. I don't know if you can see from my eyes. I had to go to bed. I had to get some rest. I'm barely getting 3 hours a night as it is, so I had to cut bait. Last night, Justin Baldoni showed up on the docket with everybody else opposing Blake Lively's motion to get treble damages, attorney's fees, and punitive damages. We had that conversation a couple of weeks ago now discussing that. And we also had that video with Little Girl Attorney breaking things down further. If you didn't have a chance to see that or don't understand what any of these things mean, it will take a while for me to explain everything all over again. So it would make more sense for you to go watch one of those videos to catch yourself up in case you didn't have a chance to see that. So we're going to jump right in here. It's 22 pages. I'm going to try to break it down and chop it up, in bite-sized pieces. I am also hungry. That's why I'm equating the pages with bite-sized food. For the second time, plaintiff Blake Lively seeks, my favorite word so far, draconian. And that just means excessive, harsh. It's out there. It's pretty big, right? Draconian relief under a new California statute 47.1. And you guys will also remember we talked to Little Girl Attorney about that and her feelings on 47.1, which I share, where that no judge, no New York federal judge is about to touch 47.1. And it's also important to know the judge did not base any of his ruling when he dismissed Justin Baldoni's lawsuit against Blake Lively on 47.1. He didn't touch it. In fact, he made it a point to say he didn't base any of his ruling on 47.1. So the fact that Blake and her team are using this 47.1 as a straight up basis to determine whether they get their money's worth or not is kind of ludicrous. What 47.1 is meant to do, at its basis, is to protect people who are accusing somebody of sexual harassment from being retaliated against, right? So you would feel like somebody legitimately, accusing somebody of SH would have the right to file said, harassment claim without feeling, scared or retaliation from the other party. But the main thing you need to understand about 47.1, you have to have a really good, reasonable basis to file your SH claim and for it to work for you as far as the retaliation side of things. Also, there cannot be malice, right? Like you cannot act on malice, hatred, revenge, intent to harm, anything of the sort, which keep in mind, Blake Lively has not proven that. There is nothing she's given us to show there was no malice here, there was no intent to harm here, because again, we have the proof that she went to the New York Times ahead of time. We know now somebody was recording Steve Sorowitz. We also know that the CRD tried to investigate and she shut that down. All those things will kind of go to prove a little malice here, a little revenge here, a little intent to harm here. You also factor in Ryan Reynolds, doing the whole I'm pretending to be Justin Baldoni in my movie. This was coming, right? That you didn't wake up one day, was like, I'm going to fight for myself. I was SH against. You did not take the necessary steps. You just went from, I'm in bed one day, I'm going to sleep peacefully, to lawsuit. A pretty big one of that, right? And now you want this law to apply, even though you don't live in California. And this rule, technically, even though it can apply out of state, it shouldn't be. But you filed in California because you knew about this law, or your lawyers did at the very least, right? The reason things are a little complicated right now as to why nobody can really apply this law is nobody has been able to prove whether Blake did this with malice or not, right? So we're kind of in limbo, if you will. and we're kind of giving her the benefit of the doubt, even though everybody is still looking at her sideways, including the judge, might I add. So again, which is why Judge Lyman has refused to touch 47.1, if you will, because there's no clear path here to take. And it is also important to mention, and I'm going to belabor the point, there is no precedent when it comes to 47.1. No judge, no court has ever seen or used it before, right? So we're uncharted territory. So to ask a New York federal judge, at the risk of, repeating myself here, to ask a New York federal judge to rule on a California law for the very first time in such a big case is kind of ludicrous if you really think about it. And I don't think this judge wants anything to do with it. I don't blame him either. It is also important to know another reason the judge might not be touching 47.1 or giving Blake everything she wants right now is if, for example, when I was talking to one of my lawyer friends about this back when we talked, if this thing was to go to trial and a jury was to find that Blake is full of shit and her claims are not valid, because you've already dismissed Justin's claims under the law, if you say you use 47.1, you muddy the waters even further, right? Because the reason you dismiss Justin's claims is you claim he didn't have enough meat to it, right? He didn't give you enough proof. He didn't prove malice. But again, you can't go ahead and now give her punitive damages and treble damages and attorney's fees. Like, you've given her enough with the dismissal already. So you most certainly don't want to touch giving her extra money, punishing Justin for trying to simply fight for his life if you didn't apply 47.1, unless Blake has won her case and now you can stand on it. Which is a point my friend Little Girl Attorney made earlier when she said something to the effect of she doesn't even see the judge making a ruling on this until we've gone to trial and we have an outcome about Blake's case before he would even consider this, which is a possibility. I didn't know you could wait till after the trial to determine punitive damages and all of that. They say right here, the application of 47.1 to the dismissal of consolidated complaint while the main action is still pending also raises a specter of inconsistent outcomes. Like I said, you don't want to rule on it now, then you go to trial, then you find out it's going to be so messy and so muddy. Like, you don't want this if you're the judge, right? For instance, if this court applies 47.1's privilege and remedies at this early juncture, what happens if a jury later finds, what happens if a jury later finds her claims lack merit, right? Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the tier of fact. In some way, the fact that this law has never been applied and never been used and never been heard of is such a blessing. In another way, it is so maddening. It is so frustrating because, nobody wants to touch it. Nobody knows what to do with it. So in a way, I'm grateful. I'm thankful for that. But in another way, also, it's like, oh my God, I wish somebody knew what to do with this, right? Lively, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegations of the Wayfair party's purported misconduct, which are the basis of pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. The bulk of these allegations have no bearing on the discrete factual issues relevant to Section 47.1 analysis, specifically whether Lively had a reasonable basis for a sexual harassment claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed the Wayfair party's defamation against Ryan Reynolds and Leslie Sloan for failure to plead malice, which I said earlier, right? Sufficient evidence. I'm sorry. I know I'm reading this to you guys now, but because I have the facts of this case in my head, sometimes I say things before I've actually read it. So it's kind of like I'm calling it back. I'm going back. It's just my brain is like, girl, I thought we already had this conversation. I don't know if that makes sense to you guys, right? Sufficient evidence of a smear campaign and strong evidence that the Wayfair party spread negative stories about Lively. Pretty much, Blake is writing checks her body can cash. Blake is asking for things she can't get until we get to certain parts of this case. She wants certain protections that she cannot afford. Not like her afford like monetary wise, but she's asking for certain protections the court can in good faith not give you because we haven't like touched that part of the case yet. We haven't established certain things in the case yet for you to get those kind of protections, right? Before I lose you, I just want us to get to the crux of it. Blake wants to use 47.1 as a cloak of, as a blanket to cover herself and shield herself and walk around untouched. But what she doesn't understand is in order for 47.1 to apply, in order for the judge to in good faith let it apply, we have to get to a point in this case where the court or jury or somebody can confirm that you are an honest and reasonable person, right? And so far, there's nothing you've done that shows us you're an honest and or reasonable person. We can't really believe anything you're saying because, again, she skipped so many steps. The only time we hear about this SH case is when she's asking for money. She doesn't even talk about it on a regular basis. I'm pretty sure if you're the judge, you're like, oh my God, like she cares more about her image more than what she's claimed happened to her, right? Blake is more times on the docket, if you're really going to be honest, and I think I could take the time to look this up. The amount of documents that's hit the docket and her lawyers complaining has been more about a smear campaign and her image more than it has been about SH. And if we're going to be real, that is probably one of the things that's keeping the judge from allowing her to run rampant on his docket, even as much as she is already, right? He's still keeping her at bay a little bit. And that's probably because don't nobody believe her. Where a tier of fact finds that punitive damages are warranted, the Fourth Amendment prohibits against excessive penalties, such damages to a maximum of 3 times the actual compensatory damages awarded by the jury. The questions of whether 47.1 permits punitive damages to be awarded as a matter of right or how punitive damages would be calculated absent an award of actual damages where a defamation claim has been dismissed or the motion to dismiss have not been answered or even addressed by the court. The plethora of serious constitutional and other legal questions have not been addressed by a California court, raising a preliminary question of whether this court, as a matter of first impression, should apply 47.1. Right at this point, we're now heading into the amendments. And the biggest thing, if you really want to think about it right now, is they're saying that like there's serious constitutional, legal, jurisdictional problems with giving you this because you claim the Fourth Amendment or whatever amendment applies here, right? If we're going to look at this in plain English, 47.1 is starting to look like it might tamper with the U.S. Constitution. First Amendment, to be exact, because what is the First Amendment? Free speech. Anybody can say whatever they want without fear of, prosecution or penalties or whatever, right? So if you're looking at trying to claim your amendments apply and everything, well, the First Amendment guarantees a right to free speech. In a petition to the government, like filing a lawsuit, like you can't just sue me for saying what I want if I believe it to be true. The basis of this video, if you've made it this far, is nobody wants anything to do with 47.1, right? That doctrine, the North Pennington doctrine, in plain English, states that you cannot punish somebody just for suing somebody, even if they lose, as long as they did it in good faith. As long as Justin sued your ass, Blake, because he believed you were coming for him in a way you shouldn't have, even if he loses, even if the judge dismisses his claims, you cannot sue him just for that. Does that make sense? Okay. When you turn around, 47.1 does exactly that. It literally punishes people for bringing a lawsuit and for losing a lawsuit, or actually for bringing a lawsuit in general. But you turn around and 47.1 is sitting there waiting to punish you for suing somebody in good faith. Whether you lose or not, the key word here is good faith. I am suing you because you're talking shit about me that I don't think I deserve. Whether I lose or not, I still feel that way. But 47.1 doesn't even allow that to happen. See, messy, right? The waiver parties also make the claim that nothing really important happened in California. So they don't even know why Blake went to California in the first place. We're going to jump down here. Likewise, nothing in the legislative history of Section 47.1 indicates the legislature had any intent for this statute to operate outside of California, even though it can. Like, it was not meant to do that, right? It was a California law meant to work in California. Because 47.1 is silent on the geographic scope of its application, and there's no expression of legislative intent for it to apply extraterritorially, the presumption applies in full force, and lively, a non-resident of California cannot invoke it for conduct occurring outside of California. Like, if you live there, fine. You don't even live in California. So again, if this was not with malice, if this was not pre-planned, sat down and thought about why did you go to California to file this in the first place? You didn't need to. Blake hasn't given us any reason why she went to California. One, she lives in New York. The alleged SH you're claiming did not happen in California. It happened in between New Jersey, Hoboken, and New York, that area. The defamation lawsuit you're complaining about was filed and dismissed in New York by Justin. The company you're suing, Wayfair, is based in California, but that's it. They just have an office, and that's not enough. The office is in California, but the production happened in New Jersey/New York. So what are you here for with this California law? Again, if this wasn't pre-planned. In the past, this claim here by Wayfair say, and they cite multiple case laws to prove in the past, multiple judges, multiple courts have rejected multiple cases trying to use this exact tactic, but somehow Blake gets away with it. The courts typically would require a stronger connection with California in order to allow this charade in their court in the first place. So for everything I just stated, and literally the basis of this entire video is to say 47.1 should not have any room here to breathe. 47.1 has no bearing on anything and should really be stricken and just taken out to pasture somewhere. So I hope that was informative. I hope that was not too boring. I know it was very, very law words heavy. I try to make it as broken down and as fun as possible, but this is the best I could do. Again, I wonder if you guys are exhausted of us. Let me know in the comments, but I appreciate you for being here. I have something fun for you guys that I just found out about 40 minutes before I read this. It's about our friend Colleen Hoover. Check that out when you see I post that. Apparently she might have seen my video that I made about her trying to use this case for publicity. She's fighting back. But I appreciate you guys for being here. Thank you for your time. Please make sure to like, share, subscribe, leave a comment, and I'll see you in the next one. Have a good day. Bye-bye.